Okay, I'm joined today with Bita Lisi, who is the owner of Stonegate Legal Services in Toronto. Is that correct? And you represent primarily landlords at the Landlord and Tenant Board in Ontario. Is that accurate?
That's correct. Good morning,
Good
Tegan.
morning. Thank you so much for joining me today. I'm really excited that we could do this. Thank you for your time.
Thank you for having me. I'm really excited to do this today.
So glad. I couldn't think of anybody better to sort of start with the basics of navigating especially in these COVID times, navigating the landlord and tenant board in Ontario, particularly for people who really have landlords and tenants who have very little experience with this. And perhaps we can start off a little bit of talking about certain notices. And I know we wanted to get into a little bit of what an N12 notice is. Can we talk a bit about that? I know people have heard of that, and maybe it's been in the news a bit that some landlords have tried to use that as a loophole to evict tenants. Can we talk about the N12 a little bit, Bita?
Absolutely. So
Thank
let's
you.
talk about the N12. The N12 can be used in two circumstances. So if the landlord requires possession of the property, or if the property is sold and the new purchaser requires possession of the property.
Okay.
So if the N12 is a notice to end the tenancy for the landlord or the new purchaser's own use.
Okay. Okay. So now, do you have to for those two reasons, is it difficult to prove? I mean, you can serve the tenant a notice to vacate, but what comes along with that notice? What comes along with that
Okay.
territory of the N12?
So the N12 has requirements. Okay, so
Okay.
let's talk about the requirements. Firstly, it's a 60-day notice. So
Right.
the first requirement would be that the termination date is 60 days from the date that you served the notice, but to the last day of the rental period. Okay, so that's the first requirement.
Okay.
If there's a miscalculation in the termination date, the landlord and tenant board will dismiss the N12 from being heard at the board.
Okay.
The second requirement of the N12 is compensation. Compensation in accordance to the Residential Tenancies Act must be paid equivalent to 1 month's rent
Mhm.
from the landlord to the tenant on or before the termination date.
Okay. The termination date on the N12 notice.
Correct.
Okay. Thank you.
Whether or not the tenant moves out. And we're going to discuss that as well.
Thank you.
Because although the N12 has a 60-day termination date, on the second page of the N12, more specifically, the third or fourth bolded box from the left down, it tells the tenant, what if you disagree with this notice? And to the right of it, it says, you do not have to move out if you disagree with what the landlord has put in this notice.
Right.
Okay.
Right.
And what that means is that if the tenant wants to contest the notice for whatever reason, if they can't find another property, if they're unemployed, if they feel that the landlord has served the notice in bad faith, for whatever reason, they do not have to move out and they can avail themselves to a hearing, which means that the landlord has to file the N12 with the landlord and tenant board,
Mhm.
wait 7 to 8 months before the board issues a notice of hearing,
Mhm.
and then the matter will be heard. The third requirement of the N12 is a declaration or an affidavit,
Mhm.
basically submitted to the board by the person who's going to be moving into the property.
Mhm.
So if the landlord is serving the N12, that declaration must be from the landlord. And that basically that declaration has to state the intention of the landlord moving into the property.
Okay.
If the purchaser wants to move into the property and an N12 was served for the new purchaser's own use, then the new purchaser would have to submit a declaration to the board or an affidavit informing the board that they require possession of the property in good faith. Those are the requirements. If the requirements are not fulfilled, the application, once in front of the board, will get dismissed.
Okay, okay. I'm going to ask sort of a big two-part question here then. I hope this makes sense. Now, say I am a landlord and I sign a declaration, but my intentions are really not to move my child into the property, but I just really don't like the way my tenant looks. Maybe they owe me, they owe me a couple $100. I just don't like them at all. Could I bring forward an N12 to get them out of here? And at the end of the 60 days, write them a bad check and say, if you're not out in 2 days, I'm going to shut off all your utilities. I mean, what are some of the consequences for if I were to do something like that, say?
So firstly, that's a great question.
Thank
Firstly,
you.
landlords cannot interfere with vital services
Okay.
for whatever reason. They cannot interfere. And when I say they cannot interfere, is they cannot shut off hydro, they cannot shut off the water, they cannot shut off the electricity for any reason. That comes with huge consequences. And what I mean by that is that the tenant will bring forward a tenant's rights application for interference with vital services, which can lead to harassment and substantial interference. And they can request remedies like a rent abatement or a reduction in the rent moving forward. So landlords should definitely stay away from interfering with vital services. Getting to answer your first question, landlords should not use the N12 as a loophole to end the tenancy. It never works out for the landlord if this N12 is used. And when I say a loophole, I mean that if the landlord and tenant relationship is that of a bruised relationship, they're not talking, they've blocked one another from social media, they're not answering each other's text messages, whatever the case is.
Right.
The N12 should not be used as basically a weapon to get the tenant out.
Right.
Right? Because per the new Bill 184, if any future N12s are served by the landlord, they have to disclose to the board of any previous N12s that were served, whether or not they were successful.
Okay. Now, can these types of matters, say, I'm using the landlord tenant, a motion has been brought forward to evict a tenant. Can you then, use the landlord tenant portal to continue to message that tenant and use that in a way to harass them to try and get the board to move you along quicker? Or should you stay away from that as well and just wait for, if there is a hearing date, will there always be a hearing date, or can it be thrown out before that? I know that's a lot of questions in that.
Yeah,
but,
let's talk about that. That's
yes.
a great question as well. So there will be, as long as the application is filed with the board, there will be a hearing date.
Okay.
Just a matter of when.
Right.
Now, if the landlord wants to use the portal as a way to harass the tenant, anything they put in writing can be submitted as evidence to make the landlord look bad at the hearing. So is it a good idea that the landlord does that? Probably not.
Right.
Right?
Right.
Now, bad faith can only be proven after the tenant moves out.
Okay.
Because that's when you'll be able to prove the intentions of the landlord if they don't do what they said that they were going to do per the N12.
Now, say the tenant does move out. It may not be exactly when the notice was ending, but they did their best to find a place and they moved out before the hearing date. Can they theoretically get that information from an ad in that time, between the time that they moved out to that hearing date, to bring forward that evidence?
Are you asking if bad faith intentions can be proven if a landlord puts out an ad?
Yes.
Yes.
Basically.
So
okay.
So
okay.
The board actually has a test to bad faith. Okay. And the test to bad faith is a 3-part test.
Okay.
3 questions, and this is in accordance to Section 57 of the Residential Tenancies Act. The board asked, the first question is, did the tenant rely on the N12 in order to move out? The second question is there an advertisement of the rental property? And the third question is, and this is the trigger question, did the person who was supposed to move in actually move in? So if the tenant relied on the N12 to move out, then yes. If there's an advertisement, absolutely. I mean, tenants can set up a Google Alert account,
Mhm.
and a Google Alert account is basically, it takes you a second to set it up, and you can input certain keywords. And if there's ever an advertisement or anything that hits the internet with these keywords, that tenant will get notified. And boom, there's your advertisement. Okay. And
Mhm.
thirdly,
Mhm.
remember, bad faith can only be proven once the tenant moves out. If that person does not move in, that like they said that they were going to in the N12, the tenant has recourse. They can bring forward a T5 bad faith application against a former landlord within 12 months from the date that they've moved out. And they can ask for up to $35,000.
Okay,
Right?
thank
So
you.
there are strong, very, very strong cost consequences when it comes to just serving the N12. That's why landlords definitely should not just use that as a weapon, because once it's served,
Right.
you can't redact it. A notice is a notice. So once I put you on notice, Tegan, I can't take that notice back.
So there's no getting out of it once it's filed. Okay.
Once it's served, it doesn't even have to be filed.
Okay. Okay. Thank you. Thank you for clearing that up, because I think, and to be fair to, normally good landlords who have a reasonable head, but maybe are thinking of using it as an option against a really, really awful tenant, don't do it. Still don't do it. It's as any type of tool, because it's only going to come back on you, like you were saying. Now, the realities of, I guess let's talk about the realities of evicting a tenant. It's not just as easy as serving a paper and they're going to leave because you tell them to, or else you can get a band of guys to show up and harass them. There are procedures. Now, is COVID delaying some of these procedures? Like, what are you looking at before you're even going to get a hearing?
So COVID has, although COVID has put a huge damper on things,
Right.
the board is still continuing to hear matters now online.
Okay.
However, there's still a backlog. Anytime you rely so heavily on technology, it can be our best friend or our worst enemy, right? So the board right now, the amount of time it's going to take to get to a hearing date is probably 7 to 8 months.
Before even getting the date?
Before, that's just to even get the date.
Wow. Okay. And how long before you're even in front of a adjudicator, judge, whatever it looks like?
It can be 3 to 4 weeks after you receive notice.
Wow. Wow.
Yeah.
Okay. So it's a process. And now, do you have any, if I know this is pretty tough now, do you have any advice for decent landlords and tenants right now with everything that's going on, who are maybe dealing with a nightmare landlord, a nightmare tenant? Is your advice just to maybe get out as soon as you can? To what's some band-aid solutions that you can maybe offer until you can get there?
Well, I'm a peaceful person. I like
Right.
peace,
Me too.
okay?
Me
And the
too.
older I get, the more peace I want.
Yes.
I always recommend to try and work it out.
Right.
The
Right.
board should be the last resort,
Okay.
okay? Because it's going to take 8 months to get there.
Right.
And nobody wants to live in pain and agony and be harassed for 7 to 8 months. I know I wouldn't.
Mhm.
So try and work it out. That's the best advice that I can give. If you're not able to work it out on your own,
Right.
seek a legal representative that is peaceful and wants to work it out.
Right.
Okay, because anyone can serve a notice and file with the board and then wait 7 to 8 months to get to the board. Anyone can do that. If you want a legal rep to help you through the problem, they can help you. Hopefully you find one that helps you, but you know that you do have a plan B if it doesn't work out. And plan B is waiting to get to the board.
Okay. Okay, perfect. And can these, once it gets to the board, are these issues resolved relatively easily if, say, the tenant has moved out and there is no money owed? I mean, if there's really nothing sort of there, can it be resolved
Yes.
fairly quickly?
If the tenant has moved out, if the landlord is bringing an application against the tenant
Right.
and the tenant has moved out, if there
Mhm.
are no monies owing,
Right.
what's the point of pursuing the application? The tenant has moved out, you're not going after them for any money. You might as well withdraw the application and move on. Only
Right.
if there's a claim or if there's an application and the landlord is seeking some sort of monetary compensation or the tenant is seeking monetary compensation, even if the tenant has moved out, those applications can still be pursued.
Right. Right. But there would be no point, I guess, just to continue to harass the tenant via the legal system once the obligations have
No,
been met
no.
at that point. Okay, very good. Thank you. Thank you so much for explaining that, Bita. And so I guess it's very interesting you're having this conversation with me. So your firm pretty much only represents landlords, is that fair to say, or do you ever represent tenants?
My firm predominantly represents landlords.
Okay.
We represent, and the reason why is because we're landlords ourselves. So
Right.
it's kind of like for landlords by landlords.
Right.
The tenants that we do represent are tenants that are encountering a bad faith application as a result of N12s being served. So what I like to say is we don't like to represent deceitful landlords. So those
Okay.
landlords that are deceiving their tenants or harassing their tenants, those are the ones we try to stay away from.
Sure.
But yes, we do represent predominantly landlords.
Sure. Thank you, Bita. And I'm going to put a link, of course, to your YouTube channel for people to subscribe. Your website, which is laid out. Your website's really neat. I really like how you've done that. And are you on other social media as well? Twitter, Facebook,
We
Instagram?
are we are on Instagram. We have a Instagram following. We're on and Facebook. So YouTube, Facebook, and Instagram are the three outlets that we're on.
Wonderful. Perfect. And I'll put a link to everything so that people can find you. And before I kind of tie off here, Bita, I'm sure you must be pretty busy these days with COVID and with, the landlord tenant board. Are there things that maybe you can suggest that people, I mean, I know this must be a learning process for everyone involved in what to look for in the future in tenants and landlords. Are there any sort of quick suggestions that you may have for people, like maybe just don't, I find one that often gets people into trouble is looking for the quickest, cheapest place they can for maybe a job before they can get into something else. Is there any advice that you can give to people to avoid nightmares in the first place?
Yeah, so let me start off by saying landlords, the best advice that I can give you is that you can eliminate 90% of headaches by properly vetting your tenants. Okay, check them out, social media, Google them, check out their credit, contact their references, their employers. Really, really do a thorough check on them.
Mhm.
And for tenants, do the same. I never understood why tenants don't do checks on their landlords. I mean,
Mhm.
obviously, the landlord's not going to give you information, but use the internet as a source of finding out information on your landlord. Google your landlord. Is this a good landlord? Is this a slumlord? What am I getting myself into?
Right.
Cheaper doesn't always mean better.
Yes. Yes. I have found that to be a number one thing when I talk to people. It was usually the cheapest place near their job, didn't ask any other questions, and that was the beginning of a nightmare. So thank you so much, Bita, for taking the time today to chat with me. It's been so much fun, like to go over this. And I know one last thing, sorry, if you don't mind. A complaint I've heard a ton about is just how difficult the landlord tenant board website, the tribunal website can be to navigate. Now, do you have a cheat sheet or something like that where you help people with that? Or do you have any recommendations? Because that's a pretty big thing, is navigating that whole site.
The portal, are you
The
referring to
portable,
the portal
yes.
is, you know
Yes.
what, Tegan, we even have difficulty
Mm,
navigating the portal. I never understood the big institutions can't have a more user-friendly website.
I agree.
But I wish I could give you a better answer, but I can only tell you that we even have problems with that portal.
Okay. Okay. So this is a universal issue.
Sorry.
Fair to say. That's okay. No, I appreciate that. Thank you. Thank you for that. And Bita, thank you so much again for doing this with me. And I'm going to send everyone to go check you out if they're having any issues with a bad tenant or a bad landlord, quite frankly. And just thanks for joining me today, Bita. It's been
Thank
awesome.
you. Thank you. I really appreciate it.
Yeah, me too. Thank you so much.